Hello and welcome back to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan, Member Supreme Court Bar Association. In today's video, we dive deep into a major constitutional controversy. Can the Vice President of India question the powers of the Supreme Court under Article 142? This debate goes beyond politics, it strikes at the heart of our Constitution and the doctrine of separation of powers. Let's decode Article 142, analyze the Vice President's remarks, and answer the big question, who's right in this battle of constitutional powers? Segment 1, The Controversy Explained. India's democracy rests on the balance of three vital pillars: the legislature, the executive, and the judiciary. But recently, Vice President Shri Jagdeep Dhankar's comments have sparked a storm. Is the judiciary overstepping? Or is the executive challenging judicial independence? Let's uncover the truth. Vice President Dhankar objected to a Supreme Court directive that set a 3-month deadline for the President to act on bill spending with governors. He asked, can the judiciary dictate timelines to the President? He further warned against the judiciary acting like a super parliament. This has ignited a serious debate on institutional boundaries and constitutional propriety. Segment 2, Understanding Article 142 and Basic Structure Doctrine. Article 142(1) of the Constitution states, "The Supreme Court may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it." Article 142 is a unique judicial tool for delivering complete justice, even if it means stepping beyond statutory boundaries. It empowers the Supreme Court to bridge legislative gaps and uphold equity and constitutional morality. The basic structure doctrine, laid down in the Keswananda Bharti case, ensures that Parliament cannot destroy the core of the Constitution, including the independence of the judiciary. Segment 3, Reactions from the Legal and Political Arena. The Vice President's remarks drew strong criticism. Advocate Abhishek Manu Singhvi said he should not have spoken on such matters. Advocate Kapil Sibal remarked, this undermines judicial supremacy and the constitutional spirit. Randeep Surjewala, Congress, said, no one, not even the President, is above the Constitution. Some BJP leaders, however, supported the Vice President, stating that the court should not behave like a lawmaker. Most notably, Dr. Nishikant Dubey, BJP MP, criticized the Supreme Court, saying, if the SC wants to make laws, let's shut down Parliament. He reposted on X, formerly Twitter, that Chief Justice of India, Sanjeev Khanna, is responsible for all the civil wars happening in this country. BJP swiftly distanced itself from this statement. Party President Shri JP Nadda officially rejected Dubey's remarks, stating, these are his personal views. The BJP has always respected the judiciary and considers it an integral part of our democracy and constitutional framework. I have instructed all party members, including Dr. Dubey and Dinesh Sharma, to avoid such controversial statements. Segment 4, Editorial and Expert Perspectives. In its editorial dated 17 April 2025, titled Out of Line, The Times of India strongly criticized Vice President Dhankar's remarks. Key observations. Dhankar described Article 142 as a nuclear missile against democratic forces, available to the judiciary 24/7, calling the Supreme Court a super parliament. The editorial emphasized that such statements violate the decorum expected of a ceremonial constitutional authority. It pointed out that the Vice President has no role in policymaking, judicial matters, or political commentary. The editorial concluded that such remarks from a ceremonial office diminish the dignity of constitutional institutions and erode public confidence. The comments were made during the valedictory session of a Rajya Sabha internship program, which the editorial termed the bitter icing on a very unappetizing cake. Segment 4A, Latest Update, 20th April 2025. Legal scholars and constitutional experts have now joined the debate. Former Attorney General Mukul Rohatgi stated that Article 142 is a constitutional safety valve and not judicial overreach. Justice, retired. Madan Lokur wrote in The Hindu that public statements by high constitutional authorities must reflect the spirit of restraint and respect, especially in the absence of legal remedies or impeachment provisions. The Bar Council of India has also issued a statement urging all constitutional office holders to refrain from making public comments that could shake the people's faith in the judiciary. Segment 5. Who's right? The constitutional viewpoint. So, who is constitutionally right? The Supreme Court, under Article 142, is acting within its constitutional domain. Article 142 is not judicial overreach, it is explicitly granted by the Constitution and has been upheld time and again by constitutional benches. The Vice President, as Chairman of the Rajya Sabha, plays a legislative role, not a judicial or executive role. Important. The Vice President has no authority to comment on, reverse, or question Supreme Court judgments. He is not hierarchically above the judiciary. There is no constitutional conflict of power between the Supreme Court and the Vice President. Their roles are distinct, clearly defined, and must be respected. Segment 6. Supreme Court's Constitutional Supremacy. Under Article 124, the Supreme Court is the final interpreter of the Constitution. Its decisions are binding on all, including the President, governors, Parliament, and citizens. The basic structure doctrine protects the court's independence. It cannot be diluted or removed, even by constitutional amendment. Recap of key legal points. Article 142, Judicial Tool for Complete Justice. Vice President, ceremonial and legislative role, no judicial authority. Supreme Court, final interpreter of the Constitution. Judicial independence, part of the basic structure, non-negotiable. Final words. This is not just a legal controversy, it's a lesson in constitutional boundaries. Healthy dialogue and respectful debate are welcome. But public confrontations between top constitutional offices must be avoided. Let's all remember, in India's democracy, no pillar is above the Constitution. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.